In this segment, we're going to look a little bit at how do you actually respond to an office action. So we were looking before in our response structure, I think in segment 312, as to a little bit of the skeleton structure that we use when we are actually arguing something from an office action rejection. So I am in the textbook, and what we're going to do in this segment is walk through a little bit about the rejection response, and I'll give you some feedback as we walk through this together. So again, I'm in segment 328 of the textbook. You see on the very first page there, this is in essence just a cover page that states what the matter is, when it was filed, the current date that the response is being submitted, and then in essence you have an introduction. In response to the communication dated XXX, we are in essence providing the following amendments. And then the next section, and usually each of these sections are on a separate page. I've consolidated them down a little bit in this template for the textbook. But for example, amendments to the specification would be on one page, amendments to the claims would be on one page. And each of these sections will correspond with a potential objection or rejection from the examiner in the office action rejection. So, for example, the very first section here, amendments to the specification, well, the examiner may not have objected to anything in the specification, in which case you obviously do not need that section. Amendments to the claims are almost 100% included, and that is where you would include verbatim the claims as they were originally filed, and you would include markup within the actual claims themselves as to how it is that the claims have been amended. As a reminder, any addition of material is always underlined. And if you delete anything from the claims, if it's 5 characters or less, you can do 2 hard brackets around those text characters. If it is more than 5 characters, then it's just a strike through. So again, if you add anything to the claims, it's underlined. If you subtract anything or take anything out or delete anything, it's hard brackets, 2 hard brackets. If it's 5 characters or less, if it's over 5 characters, then it's just a straight strike through. Like manner, you have amendments to the drawings. If it's not applicable based off of the rejection, it's not needed. But again, it is there in the template because it saves you time if in fact there is a rejection based off of that. Going on to the remarks section, I usually in the remarks always have a summary up front that indicates what was previously pending and what alterations were made to the current claim set. That helps to ensure everyone is on the same page. I will note that in this paragraph you'll see that if amendments have been made, there's a sentence there that says, 1, no new matter is introduced, and that is important to always include. We cannot add anything to the specification. We cannot add anything to the claims that is not found in the specification. So we want to always reiterate that no matter is being introduced here. If new matter was being introduced, then that would be not good. And in fact, it would be in violation of the legal basis for patent protection. Additionally, we would indicate that the support for such amendments are found, and then you would provide the exact support, whether that is former claims that are now being incorporated into the independent claim, or a specific paragraph from the originally filed specification, or from the figures as they were originally filed as well. So it just provides a basis to say, you know what, I didn't pull these amendments out of clear air. They really are found in the specification as originally filed. You'll notice that the allowable subject matter section, it just simply relates to if the examiner has indicated that something is potentially allowable. For example, often the examiner will say, well, almost all the claims are rejected. Claim 18, if written in independent form, would be allowable, or something along those lines. And so what you can do is you can incorporate that specific claim into the independent claims, and if that's the desire of the applicant, or at least with the approval of the applicant, then you can actually proceed forward and just include that particular section that makes it a very fast and easy office action response. Namely, we have incorporated the allowable subject matter, therefore it's in a state for allowance. Sometimes we have an IDS has been submitted, but it has not been approved of, or I should say acknowledged by the examiner. So when you submit this IDS, and the examiner is supposed to review the entire contents of the IDS, and based off of that content, then they go ahead and mark it as having been reviewed by the examiner, him or herself. And so what we want to do with respect to this is make sure that it actually is being acknowledged, that it has been considered. If it has not been considered, that is the point of this paragraph. Rejections based off of double patenting. And this relates in particular to the grounds of non-statutory obviousness. Now, what this usually is, if it's a non-statutory obviousness double patenting rejection, is that the examiner is saying your claim set looks awfully similar to another claim set, but it's a provisional rejection. If the examiner is actually relying on a different basis, so if it becomes a statutory obviousness type rejection, then you actually need to take action. But if it's a non-statutory obviousness rejection, then it's provisional, in which case you can say, by all means, we will file a terminal disclaimer if it is needed later on, namely when the claimants are in a position for allowance. And if at that point it is still necessary, then by all means we will file a terminal disclaimer. We have an objection to the specification section. Obviously, if there is an objection relating to this, then you would also fill out the amendments to the specification section above. We have the 112 section, so 112A, 112B. Again, if any claims have been rejected under either of those, then you can respond in part. Under claim section 101, now I would indicate that 101 is literally a moving target. So what is applicable in this template right now may not be applicable 1 month from now or 5 months from now. The courts are constantly changing how it is that they are construing 101, which makes it a lot of fun. So, but the reality is that in view of that, this is just one exemplary response of how to respond to a 101 rejection. I would recommend looking for the latest guidelines from the USPTO in relation to 101 if you do get a 101 rejection. I have a section there for amendments after final office action. Now that usually, for the most part, we do not, in the clinic, usually get to the point where we have something after final, meaning that we then have to take some action and file an RCE, a request for continued examination. So this paragraph here is a stock paragraph that I've included. The reality is that in the clinic, we have never had to use that paragraph. Why? Because we have not had to file any RCEs. Then we get down to the rejections under 102. And you'll notice that under the 102 section here, we have the same skeleton framework that we previously analyzed in the response structure of segment 312. So we have the introduction section, we have the amendments to the claims themselves, and then we have the particular argument section where we say, where we show the comparison between what the examiner is rejecting, what the prior art is teaching, and how the claim language is not being taught by the prior art excerpt. Under 102, we have a stock paragraph afterwards that in essence says, the test of anticipation requires that all elements of the claim be taught by the prior art, one prior art. And in this case, because not all elements are being taught, the test of anticipation is not being satisfied. Under rejections for 103, you'll notice a similar type format as far as the skeleton structure, where the rejection basis is being provided, and then last but not least, you have the comparison document or the comparison paragraph that shows how it is that the excerpts, the subset of the excerpt relied upon by the examiner is not being taught by the claim language, or rather just the flip of that the claim language is not being taught by the excerpt itself. You'll notice that there is, again, another stock language paragraph following the 103 argument section, and this stock paragraph just walks you through basically that the test of obviousness, in essence, all elements of the invention must be taught by a combination of the prior art, and in this case, In short, because one limitation is not being taught, then the test of obviousness is not being satisfied. We next have a section relating to official notice, and this is where the examiner says, you know what, I don't even need a reference to teach the particular elements that are being rejected here. And so usually in a legal context, you can have official notice within a court of law. For example, it's usually very mundane things that the court would not have any objections to. For example, on October 26th, was it a full moon or a half moon? So the court could come in and say, you know what, we take official notice that on October 26th of 2015, there was a full moon that night. It's an undisputed type of assertion that is being made in the court. In like manner, that is what is going on here. So the examiner is trying to say, oh, this is undisputed, and I don't even need a reference for it. You generally don't see that. Why? Because the examiner needs to put forth a reference. If it is so obvious, then why aren't they actually just picking one reference to show? So usually it is not common for them to rely upon official notice unless they really feel it is just so obvious it's not even worth their time drumming up one reference for that. So, but if you do get an official notice, you need to make sure that you respond to it, because if you do not, it will go down on the record as you did not respond to the official notice rejection, in which case it is deemed accepted, namely that whatever was being contended by the examiner under official notice is now noted as being accepted as official notice. So if you do not respond to official notice, it goes down as being officially accepted. There's a section there for dependent claims as well, and generally speaking, you'll notice that the dependents follow the same exact type of skeleton structure that we've looked at before, where the particular limitation is presented, the particular paragraphs from the prior art that are being relied on to teach that limitation are provided and quoted, and then there's a comparison between the two as well. There's a section for new claims that lets you insert any new claims that are being inserted into the claim set, and last but not least, a conclusion section. So this is a very brief walkthrough of what is in our template response. You'll notice that for the most part, a lot of it comes down to the skeleton structure that we have already discussed previously in segment 312. So if you can really master that skeleton structure, it will assist you with actually filling in most of the rejection template response.